Elsewhere, the Ethics and Anti-Corruption Commission, EACC, has faulted a decision by the Anti-Corruption Court on Thursday, allowing graft suspect and City Hall employee Nahashon Wilson Kanani to keep assets worth 643.2 million shillings, assets which the EACC maintains are unexplained and should thus be forfeited to the state. Now, EACC says the decision by the trial court disturbs the established legal principles and standards, and that, if allowed to stand, potentially reverses the jurisprudential gain made so far in recovery of stolen public funds and assets. As our senior reporter Ibrahim Karanja now reports, the Commission has indicated its intention to appeal the decision.
When Nahashon Wilson Kanani was first brought to the attention of the public, the country was told of how a junior employee at the Nairobi City County, serving as a Development Control Officer 2 at Urban Planning Department and earning a gross monthly salary of 88,530 shillings, had amassed wealth disproportionate with his known legitimate sources of income. The Ethics and Anti-Corruption Commission then said that it immediately began investigations into Kanani's assets worth 1,054,917,466 shillings, and that the man was only able to satisfactorily explain 407,146,589 shillings, and thus making the remaining 643.2 million shillings as unexplained wealth. This made the Anti-Graft Commission to move to court under Section 53 of the Anti-Corruption and Economic Crimes Act, EACC, seeking forfeiture of the assets that included 4 high-end motor vehicles, 5 land properties in Busia, Naivasha and Nairobi, cash domiciled in 14 bank accounts, and cash in 2 M-Pesa accounts. Kanani's wife, Regina Munyiva Mutinda, as well as 4 companies associated with him, were also listed as respondents. However, Justice Nixon Sifuna disagreed with EACC's position that the assets were acquired through corruption since the salary was meager, saying, and I quote, that a junior employee who wisely invests his supposedly meager salary will have more assets than an executive that spends his otherwise humongous salary on leisure and sin. Therefore, the Commission fell into error in proffering that the first respondent's allegedly meager salary should be his only legitimate source of income, and therefore the sole yardstick for rationalizing his assets under EACC. End of quote. The court that termed this as a case whose proof is on a balance of probability due to its nature as a civil case also found that the respondents have satisfactorily explained the sources of all their assets by supplying statements, and thus dismissed the suit with no orders as to cost. The EACC has now moved to the appellate court seeking to challenge the decision. EACC avers that Justice Sifuna's decision has reversed the current legal position, where a person is unable to explain to EACC how they acquired their assets. The burden of proof shifts to them to demonstrate that the assets were not acquired through corruption.
The Commission finds this judgment inimical to public interest, and if allowed to stand, it will disturb the established legal principles and standards that constitute the progressive jurisprudence that has seen the country make significant gains in the recovery of stolen public property. We will be challenging the entire decision before the Court of Appeal with a view to having that judgment overturned.
Ibrahim Karanja, NTV.